establish equality for freed slaves. Now, didn't last very long because in Plessy versus Ferguson in 1896, and this, of course, comes on the heels of the abolition of Reconstruction and the introduction of Jim Crow laws. The court establishes separate but equal principle that justified, in that case, Louisiana's segregation of train passengers by race, and of course it spread to many, many other areas also. Justice Harlan, in dissent, argued that the Constitution should be colorblind, and this becomes an extremely important metaphor for the Supreme Court of the United States in resolving cases involving classifications based upon race. Now, post-Plessy litigation was aimed at dismantling separate but equal, and the court did that finally in Brown versus the Board of Education and subsequent cases. But the problem has persisted as to how we ought to view the use of race. And there are two primary opposing views that you see emerging in Supreme Court opinions. One is that in order to make race irrelevant in the future, race has to be irrelevant now. And of course, that's the position that Chief Justice Roberts takes. The other one is that in order to make race irrelevant in the future, race has to be considered now in righting the injustices of the past. And it's important to understand that we have a 400-year and counting history of abuse based upon race in this country. Now, as a second view, Justice Blackmun, Justice Ginsburg, Justice Jackson pretty clearly take that position. If you want to make race irrelevant in the future, you have to take into consideration gross injustices of the past. All right, now affirmative action, just really briefly, Board of Regents versus Bakke is a key case in 1978, and in Bakke, the Supreme Court of the United States held that a quota system in a California medical school that set aside 16 spots out of 100 for racial minorities was unconstitutional. Now, the opinions were fractured. There wasn't any clear opinion, but what came to be the controlling part of that opinion was written by Justice Powell, who said that if there's a holistic review of an applicant's file, and this is based on the Harvard model, then it would be constitutional to use race, but race only as a factor. It couldn't be a key factor. There couldn't be quotas. So that's the Bakke case, and that's the model that most colleges and universities follow. All right, well, we jump to, and by the way, there was a strong dissenting opinion. 4 justices dissented and said that race, anytime it's utilized, should be subject to strict scrutiny. So the strict scrutiny concept emerges in the Bakke case. Racial classifications involving admissions are subject to strict scrutiny. The dissenters said, sure, strict scrutiny applies, but it's fair for colleges, universities, medical schools to take into consideration race. And why? Because of the gross injustices of the past. Universities have the right to take race into consideration in writing those injustices. All right, well, City of Richmond versus J.A. Croson in 1989 is an opinion written by Justice O'Connor. And in that opinion, the court decides that all race-based classifications, whether they're benign or invidious, are subject to strict scrutiny. In Grutter versus Bollinger, this is the case involving the University of Michigan Law School, which had adopted a holistic review process. The court held that that process was in fact constitutional. Now, Justice O'Connor did indicate in that particular case that there should be deference to law schools and institutions of higher education to make determinations based upon the importance of diversity and putting together a class. All right, so law school education is more about just learning torts and property and so on. Law school education is really important from the standpoint of diversity. Students learn better if the student body is diverse. So some degree of deference is owed to the university, Justice O'Connor says, but she also says, of course, no quotas. But in Grutter, she also takes the position 2003 that she hopes that after the passage of 25 years, it would no longer be necessary to take race into consideration. But I'll add 25 to 2003. So should race be irrelevant 25 years from 2003, 2028? Not too likely, right? Gratz versus Bollinger involved race as a tipping point, and it was an overuse of race as a key factor. The court held that unconstitutional, and this was undergraduate school in Michigan. All right, you can start to see what's coming in parents involved in community schools versus Seattle School District number 1. This is an opinion written by Chief Justice Roberts. Chief Justice Roberts suggests that diversity has no place in public school education, K through 12. But even making that assumption, he decided that the way race was used to manipulate the design of schools or the racial diversity of schools in Seattle was unconstitutional. All right, but given the opinion of Chief Justice Roberts, you can just see what's going to happen if the composition of the court changes and if the court gets the right case. And I've told this to many people. Even before the Students for Fair Admissions cases were decided, if you want to try to figure out what the court's going to do, go and read the Seattle School District case, and you'll have a roadmap of what the court's going to do. Fisher versus University of Texas, 2 cases. Fisher 2, written by Justice Kennedy, keeps affirmative action alive under a holistic review. All right, so at least as of 2016, affirmative action is still live and well in higher education, but not so after the Students for Fair Admissions cases, one involving Harvard and one involving the University of North Carolina. Both of these admissions processes are very complex, but for the court, the key factor was that race can be and is a factor in the admissions decisions of the universities. Okay, the issue is pretty simple. May a university make admissions decisions that turn on an applicant's race? Well, the answer in a 6-3 opinion written by Chief Justice Roberts is no. All right, and I guess the question is, why is that the case? As of 2016, in the Fisher case, and ever since Bakke in 1978, a holistic review making race one of many factors to be considered in college university admissions has been constitutional. All right, so what changed? Well, all you have to do is to look at the composition of the court. The composition of the court changed. Have the principles changed? Well, once again, as I say, go back to Chief Justice Roberts' decision, 2012 in the Seattle School District case, and you see the roadmap. In fact, you could almost take that opinion and apply it verbatim to the Students for Fair Admissions case. All right, there are a number of problems, the court says, with these opinions. They can't be reconciled with the guarantees of the Equal Protection Clause. They're not sufficiently focused and measurable in their objectives. They unavoidably employ race in a negative manner to the disadvantage of other racial minorities. They involve racial stereotyping, and there's no meaningful endpoint. And the court says we've never permitted admissions programs to work in that way, but it seems to me they have, of course, in the Fisher cases, and we will not do so today. All right, strict scrutiny applies. And under those circumstances, the court calls it a daunting 2-step examination. And when you take constitutional law, a lot of the course seems to be spent on the liberties part and trying to determine just exactly what standard of review applies. In cases involving race-based classifications, the court applies strict scrutiny. That requires proof of a compelling governmental interest. And then race is used. The government's use has to be narrowly tailored. In other words, it has to be necessary to achieve that interest. Okay, so strict scrutiny has to be applied. Well, what are the compelling governmental interests? Well, one might be diversity in higher education. Another one might be remediation of specific identified instances of past discrimination that violated the Constitution or a statute. And the other one, avoiding imminent and serious risks to human safety in prisons, such as a race riot. Well, this is really pretty narrow, and that might be drawn from Johnson versus California, 2005. The Supreme Court decision was written by Justice O'Connor. All right. So there might be a lot of other interests. We ought to be very important to have diversity in employment. Okay, well, if you're trying to figure out how affirmative action works, these are the only compelling governmental interests that are going to be sufficient to justify race-based classification, if they ever are. All right, so remediation of specific identified instances of past discrimination. Okay, I can give you an example of this, and this goes back to the Croson case from 1989, the affirmative action case involving Richmond's minority business set-aside program. And the basic rule that emerges from that is, if you want to fix it, you have to show that you broke it. So Richmond was trying to rectify past discrimination in the subcontracting business. Well, if Richmond didn't discriminate, and Richmond couldn't fix the problem of past discrimination, even if it's a recognized nationwide problem. So keep that in mind. If you didn't break it, you can't fix it. And that was essentially one of the problems with the Seattle School District case also, because the Seattle School District case hadn't previously discriminated on the basis of race. If you didn't break it, you can't fix it. All right, and then diversity in higher education. All right, so what's left of that? Well, not much. And we'll get to that in just a minute. All right, so court misuses Brown versus the Board of Education. Right to a public education has to be available to everyone on equal terms. Eliminating racial discrimination, as the court says, means eliminating all of it without regard to any differences of race or color or nationality. That's a universal position going back to the Yick-Wo case in 1886, the wooden laundry case in San Francisco. Okay, now one of the problems the court says is you can't measure the interests that are advanced as compelling, and these are all extremely important interests. Training future leaders, preparing graduates to adapt to an increasingly pluralistic society, better educating students through diversity and producing new knowledge from diverse outlooks. These are all really important. These are things that we strive for in our teaching and our law school. Other colleges and universities strive to achieve these goals, but you can't measure them. There's no meaningful connection between the means employed and the goals that they pursue. All right, so the court says you simply can't establish a connection. And if you can't measure how the university is doing in achieving those particular goals, then you can't meet the strict scrutiny standard. All right, so it seems to doom affirmative action, right? Now, the universities argued that they're due some deference, and certainly that was the case in Grutter. Well, the Supreme Court chips away at Grutter. Universities can define their missions as they see fit. The Constitution defines ours, the Chief Justice says. All right, so racial classifications are simply too pernicious to permit anything but the most exact connection between justification and classification. Race can't be a negative, and it can't operate as a stereotype. It's worked to the disadvantage of Asian American students. It's resulted in a significant decline in the number of Asian Americans submitted to Harvard. And there's no logical endpoint. Rutter said 25 years, all right? Court says that race is always going to be relevant, and that's one of the problems the court sees with the affirmative action programs. Race is always going to be irrelevant. How do you ever know, for example, whether you have a critical mass of students to achieve the appropriate diversity? How will you ever ensure that race will at some point stop being a factor? The court says you can't. And periodic review, which the court in the Fisher case says is sufficient, the Supreme Court in the Students for Fair Admissions case says is not. Okay, so this is what we have to go on. And for those of us who sit on admissions committees, court says nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected their life, whether through discrimination, inspiration, or otherwise. But a caveat, you can't simply establish through application essays or other means the regime we hold unlawful today. Okay, so take this, colleges and universities, admissions committees, and then you go ahead and you, according to these standards, you develop an admissions program. And I can tell you it's really a daunting, very difficult task. All right, so that's what's left of it. Race can't be considered as a factor, as a tipping factor. It can't even be considered as a factor, except in a very general way. For example, through essays in which a person might identify their race. Only way in which race can be considered. Justice Thomas concurs the advances in originalist understanding of the 14th Amendment. Most of you are familiar with that view, so I'm going to skip over it. He launches a disagreement, takes a shot at Justice Jackson, and he says the panacea she counsels is to unquestionably accede to the view of elite experts and reallocate society's riches by racial means as necessary to level the playing field. All right, he disagrees with that. All right, well, Justice Jackson writes a very, very powerful dissent. And this is the point that I made earlier. This contention by Justice Thomas blinks both history and reality in ways too numerous to count. But the response is simple. Our country has never been colorblind. Given the lengthy history of state-sponsored, race-based preferences in America, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry. And if you agree with Justice Jackson, then of course your position would be significantly different. But the point of the majority is race, notwithstanding this sordid, lengthy history in the United States. Colleges and universities are powerless to do anything about it by taking race into consideration, even as a factor in a holistic review in the admissions process. All right, so I'll stop right there, try to adhere to my time limitations, and turn it over to, I believe, the next speaker, Professor Petrie.
Thank you, Professor Steenson. So my questions were to share my experiences regarding racial equity in higher education. And it's been interesting. It becomes even more interesting after having listened to Professor Steenson's talk about the law in this field, especially considering this most recent decision from the Supreme Court. My experience has been there seems to be some double standards, if you will. On the one hand, and this seems to mirror what's going on in law, on the one hand, the argument is, well, you can't take race into consideration, but race is taken into consideration. And you don't have to look too far. You can look at the data now, you can look at the historical data and see, for example, that in colleges, the majority of the student body is made up of non-BIPOC people. And, you know, you could say, well, it just turns out that way. They're better qualified. There are more people that look like that in the country, that, you know, all of these things. But that doesn't hold water, because if that were the case, then you would say, well, then the enrollment number should be on par with what the population looks like, and it's not. The other thing that I've experienced is this argument, and this is also echoed in this decision, that, hey, if you let the BIPOC people in, you're going to kick us out. You're going to be taking spots away from us. And then there's this argument that it's a zero-sum game. If you win, then I lose. But it completely ignores the value of having diverse perspectives in the classroom. And if you look at the population now, you can look at the population of the US, and it's changed. And, you know, you may like that, you may not. You may say, oh, they cooked the numbers. You can say all these things, but the reality of it is the demographics of the US have changed. Not only that, the world has changed, and it's going to continue to change. So what do I mean by that? Well, one of the things is we now live in a global economy. It's no longer the situation, even for folks in rural areas. Sorry, my dog's jumping up and down. But even for folks in rural areas where you're simply just doing business with the folks down the street. That's not the world that we live in now. For our students that are going to go on and become lawyers, there's a high probability that they're going to be involved in transactions that are multinational in nature, that are going to be cross-cultural. That's guaranteed. And I mean that in the broadest sense. It could be dealing with people from different countries, people from different cultures, people in different generations. Right now, we have 5 different generations actively working in the workforce now. So our students will be working in cross-cultural situations. So if we are going to have people that are well-educated, well-qualified, highly skilled to go out and serve in those roles, then how do we best prepare them to do that if they don't have exposure to other people while they're in higher education? Another thing that I've experienced is this idea of intent versus impact. Well, we intend to do well. We intend to have, equitable learning environments. We're trying, but oftentimes the impact that is associated with the intent isn't very good. And I can give you some examples. So I think a lot of people are familiar with Ibram Kendi's book, How to Be an Anti-Racist. So when the book came out, he was doing his tour, lots and lots and lots of people got excited. And keep in mind the time frame for this, right? When George Floyd was killed, for the first time that I can recall, it wasn't a situation where just people in the local community, or maybe even just people from that particular race, were outraged by the killing of this man. This time, it was almost live cast, pretty close to it. A 14-year-old girl was videotaping it, and it echoed around the world. There were protests all over the world, and an outcry and a demand for social justice. And so the reaction to that was, yeah, this is horrible, and we're going to change. We're going to do something about it. And so in the wake of all of that, lots of people, I'm thinking probably with good intentions, said, yeah, we're going to become an anti-racist this, or we're going to be anti-racist that. We're going to really engage with this diversity, equity, inclusion, belonging work. And it happens frequently. Something bad happens. There's a killing of a Black person by the police, and folks are outraged. Politicians come out and they make big statements about, we're going to change laws, we're going to do this, we're going to do that. And that lasts until the next news cycle, when something else happens. And then the next thing you know, it gets pushed to the background. And so that same thing is happening in many of the universities around the country. Lots of people said, we're going to be anti-racist, we're going to do this, we're going to do that. And lots of companies, it makes for good PR, it makes for real good marketing. I've even spoken to some of the CEOs for some of the Fortune 500 companies here locally. When the rubber meets the road and there's really something where they have an opportunity to speak out against it, and they say, Rick, we agree with you privately, but publicly, we're not going to take a stand one way or another. And I said, well, why is that? I mean, it's impacting you as well. You can look at downtown Minneapolis still today. It was once a very vibrant area, lots of commerce going on. And now it's starting to come back a little bit. But, I walked around down there a couple of weeks ago. I officed downtown Minneapolis for well over a decade. And now there's lots of empty buildings, lots of retail that's gone. And it's because, there was a lot of talk, but not a lot of people really walking the walk to back up the talk. And the same thing is happening in higher education. I was also on a radio interview, it's probably a couple of months ago, within a day or two of this decision coming out. And the host of the radio show said, well, Rick, this really isn't that big of a deal, right? This decision from the Supreme Court. It just means, whether this kid's going to go to school or a different kid's going to go to school. That's really all it boils down to. And I said, no. That's a very superficial look at it, because very few people go to school just to go to school, right? There's, I guess we call them professional students. But most people use school, whether it's undergrad or grad school or law school or medical school or engineering school, whatever it may be, they use school as a bridge to go from where they are to launching a career and to enjoy all the benefits that come with that career. So it's much more than just, can this person go to school or can that person go to school? There's a lot more to it. Then I was also asked to, so let me go back and sort of put a bow on that. That's been my experience to date. One thing that I am guardedly optimistic in saying, and this is based on some work that I've done in the field of cultural intelligence. And there, Professor Gross and I had an opportunity to gather probably 40 professors from around the country. You know, the ABA came out with new standards, ABA standard 303B and 303C. B deals with professional identity. C deals with the requirement that schools are now mandated to provide training on race, on cross-cultural issues, and on bias. And so this conversation that we had with these 40-some students or 40-some professors from around the country was focused on, how do we do that? How do we actually bring that to life? The ABA didn't give a great deal of guidance, which is not uncommon. It's not a knock on the ABA. But I think what they're doing is they're looking to schools, law schools in particular, to come back to them and say, okay, this is what we're doing. This is what seems to be working. These things are not working as well. So I'm guardedly optimistic that schools around the country are starting to do this work. I know that to be true because I know a lot of the folks involved in it. I'm also guardedly optimistic that our law school is finally engaged in doing the work. I think you all know that we jumped on that bandwagon of being an anti-racist law school. Okay, great. What does that mean? What does it look like? We didn't have any standards, and we didn't for quite some time. We're moving in that direction now, and we even have professors now that are willing to engage in social justice issue conversations in their classroom. So I think we're moving in a good way. So the other question was, what are the challenges to pushing institutions to value equality on campus? Well, it's two things. One is the check the box syndrome, right? Like we said, we're an anti-racist law school, or, you know, in this class, we talk about race. And so we've checked that box. We're good to go. What do you mean? We're already doing it. But in today's world, where there are these real issues that are becoming much broader now, right? This whole thing was born out of BIPOC students saying, hey, what about us? We talk about all these other issues in the classroom, but when the issue of race comes up, frequently the reaction is one of two things. One, the class or the professor would turn to the BIPOC student and say, okay, what are your thoughts about it? And then, you know, typically that'd be one or two students in the classroom, and then it would expect that student to carry the burden of moving that conversation forward. If that didn't happen, then the response was frequently, okay, anybody have any questions? No, good. Okay, let's keep moving at about that pace, which was a signal that, hey, I really don't want to have this conversation. It feels to me like nobody else does. So let's keep it moving. So that's part of the challenge there, is how do you move this thing from talk to intent to real action? Especially in times like this, right? Because now we're starting to see that it's not just, you know, BIPOC students against non-BIPOC students. And I shouldn't say against, but I guess I'm still thinking about Professor Steenson in those cases, but it's become much broader now, right? Like as we speak, we have this situation where we have Jewish students and Muslim students at the same school, not only our school, at many of these schools. And they're trying to figure out, okay, how do we get through this situation that we're in? We have, again, multi-generational. We have gender issues. We have a lot of issues that need to be addressed. And lawyers are going to be in that conversation. They're going to be involved in shaping policy. They're definitely going to be involved in litigation matters. They're going to be involved in transactions with cross-cultural components to it. So it's critically important that we train people and have them prepared to do that. Now, there's another reaction to that in terms of challenges, and this one's even a bigger challenge, because as you know, there are jurisdictions who have come up with legislation that says you can't do this. You can't talk about things, for example, like critical race theory. They're even taking books off the shelf. And in a way, some of this stuff is silly, right? We live in the age of the internet. So there's no limit to having access to information. Okay, so you take the book off the shelf. Do you think that that really stops people from being able to access the book? And does that, somebody said, oh, Texas. Yeah, do you think that that really solves the problem? And do you think that, you know, that's the best thing to do, to have an educated populace? I don't think so. But that's where a lot of the resistance shows up. Another thing that shows up is, I think people that really do want to engage in this work oftentimes don't know how. They don't know how to have these kinds of conversations without, for example, a fight breaking out in the classroom. I don't mean a fist fight, but where students get into these big arguments and it completely disrupts the learning environment. So one of the things that needs to be done is, you know, let's look at it in the law school capacity. It's one of the places where you have subject matter experts that are teaching, but they don't have training on how to teach, right? They're really smart people that know their subject matters, but in terms of having been trained in pedagogy, oftentimes that doesn't happen. And so I think it's going to be important that people receive training on how to have these kinds of conversations, how to create guidelines in the classroom so that people don't wind up, you know, in fights and, you know, the classroom totally getting disrupted. I think if we can do that, we'll move in a really good direction. And the last thing that I wanted to share is trauma that happens inside the classroom, and also students that show up into the classroom having been exposed to trauma, and not just necessarily trauma in their lifetime, but trauma I've learned is cumulative, right? So there's generational trauma. And so we need to create psychologically safe classrooms so that people don't wind up triggered and having neurological reactions that prohibit them from learning. You want to talk about equal protection? How about an equal opportunity to learn in the classroom? So those are the things that, in my opinion, we need to do to overcome these challenges. And with that, I'll pass it over back to our host.
Yes, Professor. There's a question in the chat that says, how can we provide norms at the beginning of our discussions in a meaningful way? So I guess anybody.
Yeah, that's a great question, because that is very, very helpful. And one of the things that I do is, rather than in my classes or in the classes that I've been asked to come in and speak about this with other professors, is there's two ways you could do it, right? One is I could say, okay, my class, my rules, right? You could do that. I find it much more effective to have the class engage in a community building activity where, as a class, we come up with some guidelines as a group, and then everyone agrees to them. And sometimes we get to a point where it seems like we have an agreement, and then I'll even ask the question, okay, it seems to me like we have consensus. These are going to be the guidelines. Is there anybody that objects to these guidelines? Because if there is, then I want to hear the objection. And then from there, we can maybe negotiate to get to a point where we've got everybody on board. And it's a very effective way to go about it. I mean, here's the reality. I look at this from the lens of, how would good lawyers behave in a class, or excuse me, in a courtroom? And how would a good judge behave if you had two lawyers in the courtroom that started acting up? And by acting up, I mean they start getting after each other. I've seen it happen. In the courtroom, the idea is to keep the main thing the main thing. We're here to deal, let's pretend it's a motion hearing. Well, we've got some sort of a legal issue that needs to get resolved. So that's what we need to be focused on. But sometimes what ends up happening is one lawyer will say something, the other lawyer will internalize that to say, oh, you're saying something about me, and then now I'm going to get after you. And so now the train has left the tracks. We got these two lawyers arguing with each other, and a good judge is going to say, hey, knock it off. We're not going to do that. Stick to what we're here to deal with. Keep the main thing the main thing. And so the idea with these norms and these guidelines that are agreed to by the students is to keep the main thing and to keep students from arguing with each other, because that really doesn't get us anywhere, right? That doesn't get us anywhere. The goal of law school is to come to school, get all you can during the short amount of time that you have available to you, so that you can, one, pass the bar, but more importantly, go on and be a good lawyer. So that's my answer to that question.
That's a very great answer. I did have a question as well. So, after the affirmative action case, we now are dealing with the issues of legacy admissions, and basically, I think we all kind of saw this coming. So, I guess anybody on the panel can answer this question. Where do you see, if a possible case does come up, because you're talking about a civil rights inquiry into Harvard's legacy admission process? So, where do you see that going based on the Supreme Court's decision with affirmative action? Professor.
I think Professor Steenson's.
Then if I cut somebody else off, I'm sorry. Excuse me. But the legacy admissions case is already litigation process has started, and I guess the basic question might be who is admitted through the legacy process. And I think we could probably all agree that it's generally not students of color. All right, so you've got a system that operates supposedly in a facially neutral manner. We take legacy admissions and we don't pay any attention to race. But of course, the way the process operates, it's racially discriminatory. Legacy admissions count for, in some of the elite universities, a significant percentage of the students who are admitted. And of course, it's race-based discrimination. And so it seems to me there's an extremely powerful equal protection analysis or equal protection claim that legacy admissions processes are unconstitutional. That's my take.
Maybe can I add to that? I agree, Professor Steenson, that there is a strong claim. Do you think, though, that this court that just ruled the way it did would see it as a violation of equal protection, or would they see it instead say, "Oh, it's facially neutral"? There are reasons that have nothing to do with race why an institution might want to favor its legacy students. I mean, I agree in terms of I would kind of where I'd like it to come out, but I guess I'm a little dubious, and I don't think you were claiming otherwise. I'm a little dubious about whether this court would actually end up seeing it that way.
Yeah, my question would be how could it view it any other way? Now, of course, one of the primary problems with discrimination under the Equal Protection Clause, and this goes back to Washington versus Davis in 1967, there has to be intentional discrimination. And so if we have what in effect is de facto discrimination, in that case, it happened to be a civil service test that worked to the disadvantage of Black police officers in the District of Columbia. We seem to have a neutral policy that just happens to work in favor of white people. But this is part of an overall intentionally designed admissions process that gives a specific kick to legacy admissions. And in its application, and with the knowledge of the universities who heavily rely on legacy admissions, it seems to me there's a pretty good argument that it's intentional race-based discrimination. So my question would be, how could the court ignore it?
Professor Steenson, if I could add to that question, I guess, do you think that changes if the level of scrutiny is not strict, because it isn't, if the court were to determine that it wasn't race-based, but should be viewed on a rational basis instead?
Well, course, the promised land of constitutional litigation is to get to strict scrutiny. And if you do have a race-based classification, and race-based classifications can work to the benefit of any particular race, why should it be any different if it works to the benefit of students who are Caucasian, as opposed to a program that works to the benefit of minority students? So if we have a legacy admissions policy, one of the problems with the Harvard policy, by the way, was that it resulted in a decline of 11.1% of Asian American students. Well, what about the legacy admission students? What impact does that have on the ability of students of color to be admitted? It has a significant impact on them, just like the impact of the race-based policy or admissions policy of Harvard had on Asian American students. So it seems to me you've got inequality, and it doesn't make any difference whether the classification works to the benefit of Caucasian students or students of color. All race-based classifications have to be subject to strict scrutiny. Whether they seem to be benign or whether they seem to be invidious, we never know what they are. So all of them have to be subjected to strict scrutiny. I don't see this as a rational basis case.
There's
I see there's a question in the chat about how does this case impact diversity programs and law firms and other legal orgs, and what are these programs in jeopardy? I can speak to that if you'd like.
Yes.
Yeah, so here's what has happened since that case came out. Some politicians and some other organizations have started sending letters out to some of the law firms saying, hey, we're aware of this race-based hiring program that you have, where you quote unquote trying to increase the diversity inside your law firm. We view that as a violation of the law based on this case that came out. The reality of it is, and I'd be curious to hear from either Professor Steenson or Gordon on their take legally, but as I read the case, that case has nothing to do. They're two separate issues. And the law firms tend to be taking that same stand. They're those who are truly committed to increasing diversity in the legal profession are not backing away from that stance. I've spoken to partners at firms, both locally and even national firms, and they're not backing away from that. We'll see what ends up happening. Now, the other reality is it's the same thing where some of the law firms have diversity statements that are on their websites. And if you go and you look to see if they're walking the talk, oftentimes you'll find that that's really not the case. There's either almost no diversity or very, very little diversity. So we'll have to see what's happening there. But there are certainly firms that are saying, hey, we're here if you want to get after us, and we're going to continue doing what we're doing. So that's the good news there from my perspective. I'd be curious to hear what my colleagues have to say about it legally.
Mark, you want to go ahead?
Well, I agree that the case does not directly address it. However, I do think that you can make an argument that the case is indicating where the court may be going on that, right? The same way that, as Professor Steenson was speaking when he was talking about the history of affirmative action, he was talking about, Richmond v. Croissant, right? And there's the Adirondack case and others. I think that the court has generally, I wouldn't be surprised if they move in some kind of lockstep in terms of employment as well, right? Of course, you'd be talking about Title VII of the Civil Rights Act rather than Title VI, right? In some cases, right? And at least Justice Gorsuch in this case, made a big deal of kind of trying to base the decision also on the wording of Title VI. And of course, Title VII may be a little different in some respects, although he didn't argue that. So I would agree that kind of as a doctrinal matter, that that case has not come before the court, but I kind of fear where some of the court's reasoning leads when it gets to the employment context. Mike, do you see it in a similar way?
Yeah, I think the major problem is nice to see a question from Isaac, by the way, who was an excellent constitutional law student in my common law class, second semester of last year. Keep in mind that you have to have state action in order to have a 14th Amendment violation. So the 14th Amendment is phrased in terms of what the state can do. State can't discriminate on the basis of race. Okay, no state shall deny any person equal protection of the laws. All right, well, private persons are obviously not states, but that doesn't remove the possibility of potentially a Title VI claim, in the Supreme Court in the Bakke case melded Title VI and the Equal Protection Clause. And equal protection violation constitutes a Title VI violation. But if we're talking about employment, then the way to get at it is through Title VII or under the Minnesota Human Rights Act, because if you have, could be a law firm that in fact is discriminating on the basis of race, using race as a ticking factor in an affirmative action program. And some of the law firms, and I think Rick is correct, right, justifiably so, have programs that specifically are intended to achieve a greater degree of diversity in the practice of law. If it's race-based discrimination, it's potentially a violation of the Minnesota Human Rights Act, and it's potentially a violation of Title VII. And so if litigation proceeds against those law firms, those are going to be the paths. It won't be the 14th Amendment, and it can't be because there's no state action.
Yeah, and that's where I think reading Justice Gorsuch's concurrence here, in which he tries to, he says, hey, there's a separate base in Title VI, and then he relates it also to Bostock and Title VII. That's why I kind of see a path here that can lead in that direction.
I wonder if the position is, this is not specifically to increase diversity within the legal profession, but it's for real business reasons. For example, we have clients that are engaged in these pieces of litigation, transactions, whatever the case might be, and no different than we would need certain types of people to handle one type of thing, we need other people that can handle another type of thing. And it just so happens that from our view, these are people who are best suited to meet the needs of our client. So it's really driven by our business needs rather than some of these other types of issues or arguments that have been raised. How do you think that impacts that situation?
Well, I think that if it turns out that there's a race-based classification and we're dealing with sort of a strict scrutiny standard, then the question is, what is a compelling governmental interest? And diversity of employment is simply not a compelling governmental interest. The Supreme Court of the United States has rejected that as a compelling governmental interest.
So, are there more questions, or do you want me to kind of take it from here? Or it looks like Isaac was about to say something there, maybe.
Yeah, I just wanted to say thank you, professors. That was really helpful. I had one more question, but I don't mind if we don't answer that.
Yeah, for the sake of time, we can get to the question at the end, but I would like to move on to the rest of the speakers, if that's okay with everybody.
Okay, I guess I'm next then. And,
Yes.
and so I was given a list of questions, and one difficult thing is that I was given this. My first question is the same as a question that Professor Petrie addressed. Challenges with, what are the challenges with pushing institutions to value racial equality on campuses? He had such a compelling answer that I will just add just a little bit to that. When I think of the challenges, one challenge is we are all the products of the environments in which we have been raised, in which we have been educated, to which we have been acculturated. And I think that creates a real limit as we try to figure out how to move the ball forward here. And I think there are kind of two subsets to that. One is understanding structural barriers. I think there are many things that go on in classrooms, in schools as institutions, et cetera, from how we teach to how classes are scheduled to what kinds of interactions are expected among faculty and students. You can just kind of keep expanding it and expanding it, which raise many structural barriers that many institutions and many faculty at those institutions, et cetera, have just kind of gotten used to and accept as the norm, because that was the norm for them as students, and that has been the norm for most of their careers. And I think both getting people to realize those structural barriers and then to be able to think about what the system would look like without them is a real challenge. I think the same is true about not just understanding structural barriers, but understanding implicit biases. And I think in the same way, what's the old saying, right? That the fish is swimming in water and doesn't even realize that water exists, because that is just the environment in which the fish is used to swimming. I think the same can be said about implicit biases, and it takes a lot of self-education and, frankly, a lot of work and a lot of willing to be quite uncomfortable in terms of trying to learn and recognize one's own implicit biases. I actually think that and actually this is a conversation that Rick and I have had together, that how do you know that you're making progress? Unfortunately, given some of those limitations, it's when the pushback is strongest, right? And so a strong pushback does not mean you should stop. To me, strong pushback sometimes means, oh, you're making progress and you're moving in the right direction. And I think another challenge is also, given all of those barriers and biases, how do we come together even on a vision of what true racial equality would actually look like, right? We can see, in the affirmative action case, the court is really disagreeing on what it thinks, between the majority and the dissent, what it thinks true racial equality actually looks like. And I think the same can be true at educational institutions as well. So then I was asked to comment on, has there been a constitutional timeout? And I must admit, I kind of struggle to understand what a constitutional timeout means. And there are a couple of ways to address it. And the question says, many have argued that a strict constructionist reading of the Constitution would be that Congress, in passing the 14th and 15th Amendments, meant for the Constitution to allow the use of race to help subordinated minorities overcome the effects of former servitude and discrimination. And certainly that is, I think, a point that is made very well by Justices Sotomayor and Jackson in their dissents in this case. To me, that's not a timeout. That's actually saying this is part of what equal protection either was intended to achieve, or certainly what equal protection permits. But then if you look at the majority is making maybe a kind of timeout argument that, frankly, I have a really tough time getting my mind around. And that is that the court seems to be saying, based on Justice O'Connor's comments in the Grutter case, and then based in this case, that affirmative action policies, that they would be constitutional for a certain period of time, but then needed to be time limited. And I must admit, I just have a very tough time getting my mind around that concept, especially when you consider that the 25 years that was thrown out by Justice O'Connor was just based on the fact that Bakke had been 25 years before that case. It wasn't a matter of really, the kind of inquiry that you would expect to try to figure out, how much time is necessary. But the argument that, this is constitutional now, but it will cease to be at some point. Frankly, it's certainly the opposite of textualism, and it's certainly the opposite of originalism. And so maybe on a certain level, I shouldn't be opposed to it, because I certainly disagree with how some of those have been used. there is an argument that says, oh, if the situation changes, right, then certainly kind of what the way we should interpret the Constitution maybe should change, and that's certainly something that that I would suggest that people think about, but it seems to be woefully misapplied in this context, in this particular case. I think it raises a broader conceptual question that I think we discuss all the time in constitutional law, which is, how are the justices supposed to decide what the Constitution means, right? And you know, one of the metaphors that I use in class, and you know, that is certainly not original to me, right, is to say, okay, we are a train going across the landscape. How do we, you know, are the justices on the top of the train, are they looking backwards at where we have been? Is that kind of, you know, the history and tradition analysis, at least as it is being used by the court today, as today's court seems to define it? Of course, there are lots of problems with that, right? You know, that seems to imply that, you know, if the founders were racist, sexist, et cetera, it means that we have to continue to be racist and sexist. Or are the justices sitting at the top of the train, are they scanning 360 degrees around? Or alternatively, are the justices at the top of the train looking toward the horizon of where we are supposed to be heading? Right. And in that sense, that would be, are they looking at, are there certain underlying principles, underlying concepts that the Constitution is supposed to stand for? And they are supposed to then be applying those concepts and helping us kind of lay the track in that direction. There are many, many ways, you know, to conceptualize how the court should be thinking about this endeavor of constitutional interpretation. You know, I have, you know, there's, you know, another metaphor that's been used, right, is that the court is essentially painting on a moving canvas, but that what is happening is that as the court paints, it is also propelling that canvas forward, right? And so how do we, you know, if we think that is the right way to think about it, you know, what direction should the court be propelling the canvas forward? And I think that then leads to the next question I was asked to address, which is, has the country truly changed so much that we no longer need affirmative action? And then the last question was, what is your interpretation based on your understanding of the Constitution in relation to affirmative action? And if you don't mind, I'll address those together because I think they fit together. Has the country changed so much that we no longer need affirmative action? Well, my personal view is, of course not. And I think on a certain level, this is the debate that the justices were ultimately having. It's a debate over what is the background reality in which we exist today. You know, and they're basically saying, you know, or arguing, if you get rid of consideration of race, does that mean that there's going to be no racism or racist policies? Or does that mean that structural racism is going to run rampant? Right. And I think Professor Steenson, you know, kind of alluded to this in one of his first slides. You know, on the one hand, you have the majority's view in this case, which, and here to quote, you know, Justice Roberts from the Seattle School District case, right, in which he said the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. Right. That is one argument, that if we as a court stop this discrimination in the legal system, then that will lead to less discrimination on the basis of race in our society. I think the directly contrary argument is the one that Justice Jackson makes in her dissent in this case. You know, and just to quote one a sentence from that, she says, deeming race irrelevant in law does not make it so in life. Right. And so that is, I mean, I think there are lots of doctrinal ways to understand this case, but on a certain level, I think on a certain level, that's almost what the whole debate is about. If we agree that we want to get to a society that the train is supposed to be moving in the direction of no racial discrimination, is the best way to get there to stop the discrimination, you know, in law, the way I don't agree that that's what it is, the way the majority sees it, or must we say, look, we have to realize what is really going on in life and what is going on in society, and our interpretation needs to reflect that. So, as a doctrinal matter, here are some of the things that I would encourage you to think about. First, why is affirmative action subject to strict scrutiny? Right? Mike Steenson, referred to Richmond v. Crossan, and where the court kind of made the point that, hey, this is not just going to apply to laws that discriminate against. Well, in that situation, they were comparing it to discriminate against people of color. That we're going to use this all the time to consider anything based on race. And you then start to ask, well, why does it make sense to make that move here? When you look at it, well, why is racial classification considered a suspect classification? Why is it subject to strict scrutiny in the first place? Well, what does the court look at when it is considering whether to consider something, categorize something as a suspect classifications? Well, it looks at immutability, right? And that certainly, you can see how that certainly applies here, right? Either way, right? It looks at the ability of the group to protect itself through the political process, right? Is it typically, unrepresented or unrepresented in the political process? Is it shut out from the political process in a way that it can't have its views reflected? And third, it looks at history of discrimination, and the idea that there has been a history of discrimination against a particular group is, of course, related to the notion that this classification reflects some kind of prejudice rather than a legitimate purpose, right? That it's more likely to be based on prejudicial stereotypes. You can very easily see how when you are considering a law that discriminates against people of color, how you can run through those immutability, ability of the group to protect itself through the political process and history of discrimination, and how you can see that it meets those tests. But of course, what the move that has happened, right, over since I guess it's really now over the last 50 years, is to say, okay, we're also going to apply that to laws that quote unquote discriminate against whites. But if you did that analysis, I mean, certainly immutability, yes, but ability of the group to protect itself through the political process, history of discrimination, you would come out in a very different place. So I'd encourage you to kind of think about, gee, does it make sense? There's no doubt doctrinally, the court has said, we are applying the same test regardless. Do you accept that? Do you think that we should that should be the law? And I think that then, or I guess the doctrine, that then gets us back to the background situation argument. One of the things that has always struck me as tough to understand in this circumstance is, so the court is saying, no, we need to apply this, race as a suspect classification. But when it first accepted race as a suspect classification, it was dealing with discrimination against people of color. And so in so doing, it was actually accepting that there was prejudicial stereotyping that goes on, that there was a history of discrimination, that there was an ability of the group to protect itself through the political process. And yet it's strange that in this case here, it is saying, oh, the background, when we get rid of affirmative action, the background is going to be no discrimination, rather than the background that it has accepted is the reality when it first created the suspect classification in the first place. And so it's kind of, we accept that prejudice exists, and that then justifies strict scrutiny, but then we don't seem to accept that prejudice will continue to exist once we get rid of affirmative action. And I realize I'm painting with strokes that are too broad here, but I hope you see that that tension. And for those of you who have, already studied, taken a course on liberties, I also hope you see that, another tension in terms of levels of generality. Right? When we talk about substantive due process, we talk about fundamental rights. How can we figure out whether something, even though it is not enumerated, whether it is a fundamental right, protected by due process? The conservatives on the court generally look to find the most specific level of generality when identifying unenumerated rights, right? They say, hey, we need to find in our history and tradition that this very specific right was protected, rather than considering it much more generally, and that the general notion was protected. Whereas here in the equal protection context, we're doing the opposite. Right? Rather than saying we're going to focus on the specific, oh, has this group been discriminated against? Has that group been discriminated against? And how we rather are using that suspect classification in a much broader level of generality to say it then applies to any racial classification, regardless of the group that is being targeted. So, in my mind, as I assume you can figure out from my comments so far, there is a difference between policies intended to protect, what that famous footnote in Caroline, products, referred to as, quote, discrete and insular minorities, unquote, and policies intended to disadvantage them. And so I see it very differently through that lens. And I guess my final point on this, would be, if you doubt that there are differences, or that the background reality is societal racism, just consider the stigma argument that Justice Thomas makes in his concurrence. He is basically making an argument that one of the problems with affirmative action is that it creates a stigma for those who are seen as the beneficiaries of affirmative action, that their value, their abilities, et cetera, are going to be undervalued because people are going to assume, oh, you just got in because of affirmative action, right? Everybody gets that argument, right? But the truth is, we have had affirmative action for hundreds of years. We have, in fact, even had quotas for a good portion of that time. And I'm not aware of anybody having made an argument that affirmative action and quotas, when it existed to benefit whites, that then led to a stigma in society that those who had been admitted on that basis had not succeeded, or that their success was not valued. And so I think the very notion that we would think about stigma in this context, but not in the much more historically long period. I mean, look, I think anybody who is of my age or more senior than I, and certainly even some people who are more junior than I, was going to college at a time when the benefits of being a white male were very, very significant. And I certainly haven't heard anybody of my generation worry about the stigma that was attached to that. So I think there's a great irony there that argument by Justice Thomas and his concurrence, I think, actually is kind of proving the case that, yeah, there is a background reality of societal racism, and that's precisely why affirmative action is warranted rather than why it should be struck down. So ultimately, I think you can end up finding your way to justifying affirmative action as a constitutional matter historically, and that's how the dissent makes the argument about what the Fourth Amendment actually meant, and that at the time it was even expected that it assumed that there would be legislation passed that would actually focus on helping particular races. So you can see it through that historical lens. You can get there by questioning whether these affirmative action measures should be subject to strict scrutiny at all, right? When you're dealing with helping those trying to assist the Caroline products, footnote, quote, again, discrete and insular minorities. Or third, you can get there by saying, hey, even if you do apply strict scrutiny, that clearly this is a compelling interest. What would be more compelling, frankly, than trying to address what has been kind of the founding sin, right, since 1619, and that this is narrowly tailored. So I think you can get there in many ways, and all three of those ways lead to an outcome different from where the court was.
Well, thank you for that, Professor. That was definitely eye-opening. So now we have our two remaining speakers. We have Mr. Andrew Wold, who is the General Counsel for the Minnesota Office of Higher Education, and Mr. Frank Langen, who is the Assistant Attorney General in the Education Division for the Office of the Minnesota Attorney General.
Good evening, and thank you to Mitchell Hamlin for the opportunity to speak with you all tonight. Thanks as well to the other speakers for a good discussion on this topic. As we're all familiar with the decision in Students for Fair Admissions versus Harvard and UNC, and because I am not a constitutional law professor, I'll only speak briefly on that. As a matter of background, there are three broad functions of an institution when working toward admitting students. First is the outreach and recruitment. Second is the application review and making offers of admissions. And third is the financial aid offered. It is worth noting that in the United States generally and in Minnesota specifically, the majority of colleges and universities accept the majority of their applicants the majority of the time. In most instances, the application review process is straightforward and does not include any sort of an affirmative action review as part of the decision-making because most applicants will be offered admissions. The SFFA decision is narrowly constructed to apply only to that second step in reviewing and scoring applications. However, the logic, if that's the appropriate word, has many potential downstream effects. Relevant precedent has already prohibited the use of quotas, stated a compelling interest in diversity in the realm of higher education, and established various permissible boundaries of race-conscious admissions procedures. In what is an effective, though not stated, overturning of precedent, the majority in SFFA found that the Equal Protection Clause requires the abolition of, quote, all governmentally imposed discrimination based on race, stating that college admissions are zero-sum and the benefit provided to some applicants but not to others necessarily advantages the former at the expense of the latter. According to this definition, I think that the court has set the table for a similar decision with regard to financial aid in a case down the road. The Office of Higher Education primarily performs research, administers financial aid, and runs the Get Ready Pathway program. Notably, the SFFA decision does not directly impact financial aid or pathway programs. However, I think we can all imagine where the precedent set in SFFA could lead in future decisions on these matters. Still, for the time being, and regardless of any future outcome of a decision by the Supreme Court, the Office of Higher Education continues its mission to support the pursuit and completion of a higher education credential by every Minnesotan, and that means every Minnesotan. In 2015, the Minnesota legislature enacted legislation setting a target that 70% of Minnesota adults aged 25 to 44 will have a post-secondary degree or credential. With just over a year to go, we are still falling short of that goal, though some progress has been made. In total, our most recent estimates show that a total of 56% of people in that age range have a degree or other credential, but that looks a lot different when broken down by race. The numbers are stark. In this state, only about 33% of Black people, 28% of people of Hispanic descent, and 21% of Native Americans in that range have completed some sort of higher education. Clearly, there is a lot of work to do. While improvements in the overall educational attainment rate have been made, the state must do more to remove barriers and increase the post-secondary attainment of BIPOC communities. As of 2022, 107,000 Minnesotans between the ages of 25 and 44 will need to earn a credential to meet that 70% goal. An estimated 89,843 of the credentials needed to reach the 70% goal must come from BIPOC communities. Without providing additional support for these communities to increase their educational attainment, it is not likely that Minnesota will reach that 70% goal set by the legislation. The SFFA decision did not directly impact financial aid programs, but some state attorneys general have decreed that their institutions cannot use race in scholarship or financial aid decisions. Minnesota is not one of those states. The Office of Higher Education administers many programs in its work to effect change. The Minnesota Indian Scholarship Program was established in the 1950s, and this program provides financial assistance to eligible Minnesota resident American Indian students who demonstrate financial need. The annual award is up to $4,000 per year for undergraduate students and $6,000 per year for graduate students. In the most recent legislative session, the American Indian Scholars Program was passed, which provides first dollar tuition and fee-free pathway for eligible students to attend a Minnesota State institution or the University of Minnesota. Eligible students are Minnesota residents who are enrolled members of any federally recognized tribe or Canadian First Nation, or any student from anywhere who is an enrolled member of a Minnesota tribal nation. The SFFA decision did not address issues of tribal affiliation, and these affiliations are likely to pass muster under a similar judicial evaluation because they are based on a political designation rather than a racial designation. That means that the programs would not need to pass a test of strict scrutiny, but that an institution must only have a rational basis for the program. The Office of Higher Education also administers programs to the benefit of future teachers who belong to racial or ethnic groups underrepresented in today's workforce. The Underrepresented Student Teacher Grant provides financial assistance of up to $7,500 to students enrolled in Minnesota Teacher Prep Program, and the Aspiring Teachers of Color Scholarship Pilot Program provides assistance of up to $10,000 per year and $25,000 lifetime to undergraduate and graduate students who are preparing to become teachers and demonstrate financial need. The Office of Higher Education also administers the Minnesota State Grant. Last year, I reviewed the way that we were administering that and made a small but significant change. It was a simple determination to a complex question around statutory interpretation of what eligible means in the context of federal Pell Grants. You see, the Minnesota State Grant takes into account the amount of Pell Grant eligibility when making the determination of dollars going to students from the state. Without getting too much into the weeds here, the statute says that the amount of a state grant award can be up to a student's cost of attendance, but only after subtracting the amount of the federal Pell dollars the student is eligible to receive, in addition to various other awards. It used to be, for reasons unknown to me, that our office interpreted that to mean that if you were ineligible for a Pell Grant because you do not satisfy the citizenship or residency requirements, for instance, you would be ineligible for the Minnesota State Grant. However, that is not what the plain language of the statute says. For practical purposes, let me give you an example. If you are a dreamer, for instance, and therefore ineligible for a Pell Grant, the amount deducted from the state grant should be zero. There should be no deduction of what you would have received if you were eligible. This change in interpretation allows for state money to be awarded where federal money is denied, and has made a huge impact on a small percentage of students. Another program of particular note is the Intervention for College Attendance Program Grant, or ICAP. ICAP is a competitive grant that is intended to encourage and support efforts by post-secondary institutions and community agencies to enhance and expand pre-college awareness or intervention programs for low-income students. This program was established in 2001 and focuses on awards to programs that foster post-secondary attendance and retention by providing outreach services to historically underserved students in grades 6 through 12 and historically underrepresented college students. Grantees can receive up to $120,000 for a biennium or $60,000 per year. In the fall of 2023, the Office of Higher Education awarded $2,700,480 to 26 grantees. A few examples of those recipients and programs are the American Indian OIC with the American Indian Youth College Exploration Project, Minnesota African Women's Association with the Twin Cities African Girls Intervention for College Attendance Program, Minnesota State Mankato with the Navigator Program, helping underrepresented students during their first year of college, and the YMCA of the North with the University YMCA Achievers Program, just to name a few. Another cutting-edge program was just passed in this most recent legislative session, and that is the North Star Promise Program. This program will be implemented in the fall of 2024 and will create a tuition and fee-free pathway to undergraduate higher education for Minnesota residents by covering the balance of tuition and fees remaining after other financial aid has been applied. This gets us closer to free college for people whose families make under $80,000 per year. As I mentioned earlier, in addition to the financial aid, the Minnesota Office of Higher Education administers the Get Ready Pathway program, which is funded through the U.S. Department of Education's Gear Up grant. Get Ready's mission is to establish and implement programming that is designed to improve the post-secondary outcomes for students from low-income backgrounds, indigenous communities, and communities of color. The program partners with K-12 schools, institutions of higher education, and community-based organizations to collectively advance access to essential information and resources that help students and families make informed decisions about life after high school. Some of the ways that Get Ready does this is by having pathway coordinators placed in schools, working directly with students, offering scholarships to students in need, and facilitating college visits to institutions across the country. Some of the schools served by the Get Ready program include Fridley High School, Como Park Senior High School, and the St. Cloud Public Schools. This past year, Get Ready scholarship recipients were awarded with a total of $800,000 in scholarships, as well as wraparound services, such as advising and access to support during their first year. Of those recipients, 91% were students of color, 65% were first-generation college students, and 100% demonstrated financial need. That literally gives me shivers as I'm saying it right now. While the focus of the Office of Higher Education is on financial aid, research, and the Get Ready Pathway program, we do dabble a little in the admissions process, I suppose. Minnesota has received national attention for the direct admissions program, also administered by the Office of Higher Education. This program, which starts with the belief that all high school graduates are college material, is shifting the admissions paradigm to a student-centered, access-focused model that proactively gives students a list of colleges and universities around the state that have already said yes to admitting them before they've even submitted an application. The program started as a pilot last year with 30 high schools and 50 colleges, and is on track to expand to include all public high schools in the state in the next 5 years. This program has the potential to dramatically shift how students will apply to college by removing the "will I get in" question from the equation. I'd like to give you an example without naming names. We have one high school that primarily serves a historically excluded population that has already had 80% of its seniors this year apply for admission through the direct admissions program. And it's only October, so these students are way ahead of schedule. And we have even more time to explore their enrollment and financial aid options for next year. In the end, pathway programs and financial aid were not expressly considered in the SFFA decision. While the court effectively overturned precedent, it didn't do so directly. As such, it still stands that a compelling interest will allow certain decisions to be made by using race as a factor, but it is up to the institution to gauge the level of risk it's comfortable with. To further that risk, and to take the court stance on admissions being zero-sum, It seems clear that the court will also consider financial aid similarly. After all, there are only a finite number of dollars at play in any program. The Office of Higher Education continues to work toward closing our state's college attainment gap by promoting college access, ensuring that all Minnesota high school students know they are college material, and working to increase college affordability, work that will continue regardless of the SFFA decision. Thank you again for the honor to speak with you tonight.
Thank you, Mr. Wall. Mr. Langen?
All right, good evening, everyone. Thank you for having me and thank you for being here for the forum. Again, my name is Frank Langen. I'm an Assistant Attorney General in the Schools and Higher Education Division of the Office of the Minnesota Attorney General. As part of our responsibilities, our division provides outside counsel to Minnesota State colleges and universities. And what I can tell you, I have a few kind of bare bones slides here. Is that prior to SFFA, none of the 37 colleges and universities in the Minnesota state system were using any sort of race-conscious admissions program. The University of Minnesota has separate counsel. They have suspended consideration of race. They've also suspended consideration of legacy status. So at first, it sounds as though, okay, for my division's purposes, this decision doesn't change anything. But as we've all discussed, this decision feels like the tip of the iceberg. And in fact, the advocates who have been pushing to try to end affirmative action around the country are treating it as the tip of the iceberg. For example, there's a specific exception in the Students for Fair Admissions decision for military academies. Well, of course, guess who got sued as soon as that decision came down? And now that case is in progress. So a lot of what my responsibility has been and what my division has been working on is figuring out, okay, where is this going? What sort of other arguments are other entities represented by our office going to face? And how do we prepare for that? Staying in the admissions lane for a second, we've gotten additional guidance from the U.S. Department of Education. There was a report titled Strategies for Increasing Diversity and Opportunity in Higher Education that was issued on September 28th. And this contained a number of suggestions from the Biden administration about different areas where colleges and universities could essentially, without calling it such, work around or work within the structure proposed by Students for Fair Admissions. This includes targeted recruitment programs. There's a section about admissions practices that talks about both practices that can be adopted, such as the hypothetical discussion in the majority opinion about considering how race has impacted an individual applicant, considering where that applicant is applying from, where they went to school, the demographics of that area. The report also suggests re-examining or possibly discontinuing legacy admissions. There's certainly discussion in the report about lowering the cost both for application and for attendance. Colleges can attract a more socioeconomically diverse group, at least if they don't all cost tens of thousands of dollars a year. And then there's a discussion also about how admissions can be impacted by campus climate and making sure that in addition to reaching out to these applicants, ensuring that the campus climate is somewhere that a diverse student body would feel welcome and would want to apply. Without rehashing too much of what Mr. Wold just discussed, there's some other aspects of higher education that have been discussed and have been the subject of challenges since Students for Fair Admissions. For example, there's a discussion about scholarships. Now, under Title IX, which prohibits sex discrimination in education programs and activities that receive federal financial assistance, there's a specific regulation that addresses scholarships that are created at the bequest or will of a donor and that are sex restricted, and how to ensure there's still equal opportunity for both sexes to access those. Title IX is patterned on Title VI. There's a bevy of case law that says that they are interpreted similarly because they are modeled one after the other. Title IX came about 8 years later. But under Title IX, part of the way many schools have addressed this scholarship issue and the issue of sex-restricted scholarships or scholarships with a preference for the applicant's sex is through what's called pool and match, which is essentially everyone applies for scholarships. There's a pool of all the scholarship money, and then the scholarships are assigned consistent with the requests or restrictions that were imposed by the donor. There's no corresponding regulation under Title VI. So one of the issues that some institutions are considering, again, evaluating how they view the risk, is do you run the argument of, if there is a scholarship that has a stated or a stated preference or restriction based on race in the scholarship criteria, could you employ a pool and match system and potentially risk trying to argue that while there's no specific regulation, because they're interpreted the same and there's a Title IX regulation that allows this pool and match would be acceptable? I keep using the phrase restriction and preference. This is also a sort of distinction that has come up with many of the large law firms who have been challenged by these different groups, by the Alliance for Equal Rights, the Pacific Legal Foundation, these different entities that we were alluding to earlier. Some of the law firms have taken the position that these challenged fellowships are not restricted based on the applicant's race, but there's a stated preference for someone who is of a background or community that is underrepresented in the legal profession. And that's how some of these firms have chosen to push back on these groups. And so the question comes up, could the same thing be used for scholarships? This is not a scholarship that is limited to only members of a certain race, a certain sex, a certain other protected class, but there's a stated preference. Everyone can apply. You may have seen some news coverage a couple of months ago about a summer multicultural research program at the University of Minnesota, which was being challenged. And opponents of this program were claiming that this was restricting these research opportunities that included $6,000 stipends to only non-white students. That is an area where, again, although it's not specifically addressed by SFFA, it's probably the next line of attack, and we're starting to see that trend across the country. Another area that we're not seeing as much litigation just yet, but we're anticipating, is student group access to resources and facilities. We are starting to see some challenges around the country, less so in Minnesota, but around the country, to the existence of different affinity groups. So for example, if we get into the ripple effect on other laws and we start talking about employment under Title VII, I'm going to jump around through my own slide and I apologize, but there's not that much text on there, so I figure everybody can follow me. For example, there's a case in the Western District of Washington where a former employee of the city of Seattle has sued the city. This is another case that's being brought by the Pacific Legal Foundation. And this employee is alleging that his race as a white man became an albatross around his neck during his employment. And one of the things he points to was race related or race specific affinity groups that he alleged existed within the city, different employee resource groups. He is claiming that trainings were segregated by race, and this is at a Rule 12 motion to dismiss, which for anyone who has gone through civil procedure, you know that means we're taking everything that this person is saying in his complaint as true. This may not actually be at all what the city of Seattle is doing, or certainly a very warped version of it. But citing to Students for Fair Admissions, the court said that these allegations stated a claim upon which relief could potentially be granted, and that the city would have to prove that these affinity groups were narrowly tailored. Now, this one is a little bit different because it's the city of Seattle, which is a government employer, and so which would have these different obligations under the Constitution that might not apply to a private employer. However, even in the context of private employers under Title VII, there's been some mixed messaging from the EEOC immediately following the Students for Fair Admissions decision. So at the time that SFFA came down, and to the best of my knowledge, this has continued to persist, we currently have 4 commissioners on the EEOC. And the chair of the EEOC put out a statement after the SFFA decision was announced saying, this was not a Title VII case. This was not a case about employment. This was not a case that impacts employers' affirmative action programs. That was not before the court. Well, one of the other commissioners put out a conflicting statement around the same time saying this is a notice and a reminder for employers to reevaluate these programs and to consider if affinity groups, mentor groups, other employer resources based on race are potentially discriminatory and a violation. And one of the things that Commissioner Lucas pointed out is for the October 2023 term, the Supreme Court has taken up an employment case. The case name is Muldrow versus City of St. Louis, Missouri. And that case involves the issue of employment transfers and position transfers of employees. Normally, to state a claim for discrimination under Title VII, there has to be some sort of adverse employment action. And in the context of transfers of position, case law states that that typically means there has to be some significant or noticeable decrease in your benefits or status, salary, etc. There has to be some negative impact from the transfer in order for it to be an adverse employment action that supports a claim for discrimination. The plaintiff in Muldrow is challenging that, and the question that is going to be before the court this next term is whether a transfer that is based on or factors in race is discrimination, even if there is not a tangible negative impact to the employee. So again, as we're talking about where we think the court is going, this is one to watch. This is one where the court, again, may find another occasion for Justice Roberts to continue his clear train of cases about how race needs to just be ignored outright. The mixed messaging from the EEOC is also significant because each of the commissioners can initiate potential charges and investigations. In fact, Commissioner Lucas, the one who put out the statement suggesting that SFFA should be considered by employers and should be applied to employer-based affirmative action plans, had previously drawn some media coverage because she filed a number of charges against employers who were providing travel benefits to pregnant employees following the Dobbs decision to travel to other states for the purposes of securing abortion. And Commissioner Lucas of the EEOC suggested that this was discrimination based on pregnancy status because there were not comparable travel benefits being provided to other employees. So there's some uncertainty there as far as the application to Title VII. Title IX, as I mentioned, is patterned on Title VI. They are interpreted similarly, but this again gets into that issue we were discussing earlier about the standard of review, because sex and race do not have the same standard of review. So does strict scrutiny based on racial classifications get read into intermediate scrutiny based on sex classifications under Title IX, because Title VI and IX are patterned the same? Likely not, but it's an argument that somebody may have to wrestle with at some point. I mentioned Section 1981, that's 42 USC 1981, which provides that all persons within the jurisdiction of the United States have the same right in every state and territory to make and enforce contracts and the full and equal benefit of all laws and proceedings for the security of persons and property as enjoyed by white citizens. It's been held to apply to government contracting. And so there's at least one case in the Eastern District of Tennessee where a court has found that certain racial preferences in government contracting would violate equal protection guarantees under the Constitution. Now, that was based on provisions in the Small Business Act, but it's still another area where we're starting to see SFFA creep into other types of litigation. I mentioned affinity groups and the Seattle case. Another case that's on everybody's radar as relates to affirmative action is Coalition for TJ versus Fairfax County School Board. There's a petition currently pending before the U.S. Supreme Court. This is a case that has been going since 2020. It involves a magnet school in Fairfax County, Thomas Jefferson School of Science. I'm probably butchering the name and I apologize, but it's something similar to that. Very prestigious, had an application process that was very rigorous to go to what is a public high school. In 2020, they changed their application process. They got rid of a standardized test. They dropped a $100 application fee, and they designated a certain number of seats in each class for each of the middle schools in the district. They also informed their admissions officers or directed admissions officers to consider in their holistic review things that are facially race neutral, like the middle school that the applicant attended, and whether that was a middle school that was historically underrepresented at this high school. They have been sued. The argument is that these changes in the admissions policies had a disparate impact on Asian American students or students of Asian descent, that it reduced the percentage of the class of Asian descent, and that it reduced the number, and that this was discrimination. The Supreme Court has not granted review on this yet. However, this is one that is sending a lot of alarm bells for people who track this area, because it involves a school that did all of the race neutral things that Students for Fair Admissions and that did not touch or suggested were okay, and that are being recommended in this latest opinion from the U.S. Department of Education. This could be a huge shift. So that's one to watch. We talked about law firm fellowships already. In the interest of time, I'm not going to really go into that. I will mention that there is one case currently pending in the Northern District of Texas where Perkins Coie is pushing back on the litigation. That is a case that has been filed by an association, because one trend you see with these lawsuits is a lot of the plaintiffs don't want their name attached to it, and so they go through various different associations. And in this case, the firm is pushing back and saying, you have baldly alleged that member A met all of the criteria for this fellowship, but is a heterosexual white man. That's not enough to give this organization standing according to the firm. I am not personally versed in Texas law related to standing or the Fifth Circuit precedent related to standing, but that's an area where some of these firms are pushing back. Other firms are pushing back again on that idea of preference versus restriction and saying that we are not restricting applicants who are white, are heterosexual, are non-disabled from applying for these fellowships and these grants. Now, I think the next line of litigation that is probably going to come out of this is a sham. And I don't, as in that's the plaintiff's argument, not I'm saying it's a sham, but that's going to be the theory of the case that you're going to see next. The other area I wanted to mention where people are trying to take SFFA and use it in different areas of law is voting rights. In both the congressional redistricting case in Alabama and in a currently pending case involving polling precincts in Galveston County, Texas, we're seeing government entities who are arguing that Section 2 of the Voting Rights Act is unconstitutional because it does not contain a temporal limitation. And here in SFFA, we have taken this idea of 25 years that frankly looked a lot like dicta when Justice O'Connor wrote it in 2003, and we have turned it into and the court has turned it into this substantive requirement that race-conscious and race-based programs must have a set endpoint. Now, in the voting rights arena, we're not seeing this argument getting any traction. The Northern District of Texas did reject it, although about an hour and a half ago, the Fifth Circuit issued an administrative stay of the Northern District of Texas's order directing Galveston County to refrain from its current plan to redistrict and reset its polling precincts in a way that would have a disparate impact on non-white voters. So that's just a sampling of where we're keeping an eye out as an office for potential future litigation and future legal issues. Again, we haven't seen a lot of these challenges in Minnesota yet, but that doesn't mean they're not happening, and that doesn't mean they're not coming. So I'm sorry to end the forum on kind of a gloom and doom note about the future of this decision, but we're seeing a lot of widespread attempts to shoehorn SFFA into other areas of law around the country already. And it's been 3.5 months.
Yes, thank you for that, Mr. Langen. I will say that, yeah, this is something that we definitely foresaw, or we knew this was going to lead into other areas as well. And yeah, we just don't know how this is going to end. So that's why it was very important for us to have this forum. And I definitely want to thank everybody for being here. It's now 7:53, so I'm going to open the floor for questions and comments, and we can just go from there.
One thing that I would add, maybe this helps us pivot so that we don't end on doom and gloom, is I think when this decision first came out, a lot of people were angry. I also think that there was sort of a chilling effect that higher institutions where people thought, even if we think we're doing the right thing, we better really be careful because we don't want to wind up in litigation. But I think after that, a lot of people have doubled down and said, okay, well, if we can't expressly take race into consideration, then what else can we do? And there are a lot of folks that have remained strongly committed to creating pathways, opportunities, creative ways to make sure that this is just a new chapter in how we get students into higher education. So that's what I'm experiencing. And I can say that with a great deal of confidence. Both of my colleagues that are here tonight from the school are in that group of people that are committed. There are other organizations around the community that are also still remaining committed and doing all sorts of things to help students become better prepared by the time they submit their applications to undergrad or grad school or law school. So those things are all important, and I think they're happening. The other thing that occurs to me is like this pendulum has swung, and I can foresee that it's going to swing back because we get a little bit further down the road with this, and I can see a lot of people raising discrimination claims saying, hey, I'm equally qualified and I still can't get admitted. I still can't get hired. And so I can see that this thing could swing the pendulum back the other way, and this could turn out to be turning the same argument right back on itself. So it'll be interesting to see how this thing plays out.
If I can add, I was curious about another way that the pendulum may swing back a little bit, and that's, if we have the military academies that were specifically carved out, and the Chief Justice noted that was because they may have a different compelling interest than increasing diversity in education. And I believe it was Justice Thomas who said that that was a social goal rather than an educational goal. If there might be other institutions that may be able to come up with other compelling interests, that like a religious institution that says that increasing diversity at our institution is part of our religious goal, it's part of our free exercise, and implementing a stronger affirmative action sort of policy. If that's a way that the pendulum could swing back a little further. There are going to be institutions that push back and test limits and aren't afraid of litigation. The SFFA organization has made these threats, and there are, the state, for example. I was in a meeting with all of the other cabinet level general counsel at the and the general consensus there was that this is a very narrow decision, and it only applies to undergraduate college admissions, and if we are going to take one thing away from it, it's that we're going to keep doing what we're doing until we are told explicitly that we're not able to. And that's not only the Office of Higher Education, that's every cabinet level state agency. And that's why we have people like Frank to defend us in court.
Does anybody else have any questions or comments?
I have one kind of along those same lines. This is just more of a curiosity thing. Do you think that what is the likelihood that the military institutions will be able to pass strict scrutiny when in the amicus brief that they filed, they pretty much use the same reasoning that the Harvard and UNC were using, and that diversity was needed just for overall effectiveness? I mean, they tied it to national security, but it was in a very, I thought, in a very broad way. So do you all think there's a chance that that will be enough to pass strict scrutiny for the military institutions?
I think the one thing that's different in cases involving military institutions, and we see this play out in the First Amendment area, for example, and we see it play out in the sex discrimination cases, is that the Supreme Court of the United States over decades and a series of decisions has consistently deferred to military judgments. And so I'm wondering, excuse me, if that's going to make a difference. If there is any difference, it seems to me that would be the key difference.
I think that one other big difference is, from a historical context, if you look at military institutions and their goal to increase diversity, in their officer ranks, you know, as far as national security goes. And from a historical context, you look back at Vietnam or World War II, and you have a lot of Black enlisted people who are being pushed up to the front of the lines by a bunch of white officers. You know, that I think is a very arguable reason for national security to be a compelling interest. You know, who knows which direction the court will take it, but looking at the historical context from the last century or so, I think that they should be able to make that argument successfully. Again, who knows where the court takes it.
All right, it is now 8 o'clock. I want to thank everybody for being here. Again, thank you guys for coming. I am going to have this recording saved and added to our journal page. So for those who couldn't make it, they will be able to view it at a later date. Yeah, thank you guys for coming. I appreciate it.
Well, thank you for putting this together.
Yes.
Thanks very much, Ajuan.
Yes, thank you for the invitation to
you.
participate.
Thank you, everyone.
All right, y'all take care.
Mhm.